Seldom a week goes by, it seems, without another case of homicide in the news. And the facts back that up. According to police statistics, a homicide occurs on average at least once a week. Over the past 20 years, more than 1,000 lives have been claimed. So, who are the victims? Who are the perpetrators? And are they being punished? And also, why are there fears that government cost-cutting is leading to killers literally getting away with murder? Torben Akel reports.
For the Vercoes of Te Teko near Whakatane, not a day goes by that they don't think of their slain nephew, Hawe. In November 2009, 36-year-old Hawe Vercoe died after being assaulted outside this Whakatane bar. He was a local government representative, a school principal and a father of 4. He is now, however, one of more than 1,300 Kiwis who've died due to homicide in the past 2 decades.
His children, they will never ever have a father, their own father again, and he was taken in such unfortunate circumstances.
It's with you every time I go to town. I go past the pub where he got struck down, and it brings it all back. Sort of can't move on.
It's been estimated that for every homicide victim there are 7 to 10 surviving relatives, partners, parents, siblings and kids, not to mention friends. That equates to thousands of Kiwis alive today who've lost a loved one in this terrible way. And while this recently released police report shows certain Kiwis are more at risk, it's something that strikes across society. The report says for every 10 victims, 6 are male and 4 female. 1 is aged under 5 and 1 aged over 60. Half are aged 18 to 39. 4 are European and 3 Māori.
People out of gangs. How about
Criminologist Greg Newbold says more than 1/3 of cases are due to family violence.
Nearly half have some form of alcohol component to it. Either the perpetrator was drunk or the victim was drunk, or they were both drunk, and about 50% of all murder perpetrators already have a violence conviction.
No surprise perhaps, but they're also far more likely to be young men. Of the 622 people convicted of murder or manslaughter in the past decade, 9 out of 10 were male and 6 out of 10 aged 16 to 29. 4 were European and 4 Māori, and 4 were a relative, a partner or an ex, and another 3 a friend or associate. The fact Hawe Vercoe didn't know his attacker made his case unusual. But that attacker, Isaiah Tai, fit the bill, a 21-year-old with a history of drunken violence. Witnesses said he floored Hawe with a full-force punch in the head from behind and then kicked him in the head on the ground. His lawyer is Paul Mabey, one of the country's leading criminal defence barristers. He wouldn't discuss the case with us, but did say this about the nature of the attack.
I mean, you imagine a situation on a rugby field. I mean, to actually take your boot and kick someone in the head, it's just so repugnant to how you'd act normally. But take it into the street where there's alcohol, and it just seems commonplace now.
In Hawe Vercoe's case, though, the autopsy found it wasn't the kick that killed him, but either the punch or his head hitting the ground. And because Tai had no intent to kill with that punch, it was claimed it wasn't a case of murder. Not that intent to kill is always necessary under New Zealand law to be charged and convicted of murder, as legal academic Chris Gallivan explains.
Murder also covers those people who want to inflict some bodily injury, realise that there might be a risk of death, and actually carry on anyway and the person dies. The test is not that a reasonable person would have appreciated that there was a risk of death, but they actually turned their mind to the risk of death.
Something that's hard to prove in court, especially if, as in this case, death was caused by a single punch. Because of that, the murder charge against Tai was replaced with one of manslaughter, to which he pled guilty. He was then sentenced to 2 years and 10 months imprisonment.
I sort of expected something pretty sick, but that was a bit too sick.
A sentence later increased on appeal to 4.5 years. He wound up serving 2.5 after getting parole last November.
As a whanau, we feel that we have been delivered a grave injustice and the system has a lot to answer for.
The Vercoe's dismay at their loved one's killer serving just a few years in jail isn't uncommon for homicide victims' families in New Zealand. Of the 394 people prosecuted for murder in the past decade, 1/3 escaped a murder conviction. And while murder typically attracts a minimum non-parole period of 10 to 18 years, most recent manslaughter sentences have made parole possible after 1.5 to 5 years. There are fears now too that even more killers could get away with murder due to a more cost-driven government policy on prosecutions.
You will see way more manslaughter convictions happening than murder.
Lower sentences are going to be imposed when higher ones are justified.
At the heart of their concerns are these revised prosecution guidelines issued just last month. To be adhered to by police and Crown solicitors, notable differences between those issued 3 years ago include an acknowledgement of the hefty budget cuts being imposed on prosecutors, which have, quote, forced them to consider how to maintain fundamental prosecutorial standards with more limited resources. There's also the new case management requirements to engage in out-of-court talks with defence lawyers in order to increase the proportion of cases in which pleas are entered or charges withdrawn. And there's the green light for prosecutors to initiate what it calls plea discussions and arrangements, but what most of us know from American TV as plea bargaining. Something that's been going on in New Zealand behind the scenes for a very long time, but something that until last month prosecutors were forbidden from initiating.
The prosecution had offered this.
Christchurch lawyer Tony Gregg has used it on both sides of the charge sheet, first as a police prosecutor and for the past 15 years a defence lawyer.
As a lawyer, you're trying to get the best outcome for your client, and if your client is clearly guilty of something which is less serious than the police are suggesting, you must put that forward. And if the police haven't got the evidence for the more serious crime, or if it's just pragmatic to resolve it, then they should accept that.
Another barrister and ex-cop too, Tony Bouchier, agrees and says the practice is on the rise.
Plea negotiations is a very important part of the process. It is now becoming more important, I think. In the past, the Defence Counsel really have been behind the 8 ball as far as having any influence. It's been totally the Crown or the police decision as to whether or not they will negotiate charges. We're now in a time of extreme financial hardship. So there is now, I believe, a far more, the police are far more ready now to negotiate charges than they have done in the past.
The judges are...
Auckland's Crown Solicitor Simon Moore acknowledges that the pressure is on lawyers and courts to resolve cases before they get to trial.
The reason for that is that the court process, particularly jury trials, is very expensive. And if we're going to be tying judges up and juries up doing jury trials, then we need to make sure that we're using their time in the most cost-effective way that we can. So there is an imperative on us to identify those cases which can be weeded out before they get to trial. Now, part of that weeding out process naturally means there will be discussions between the prosecution and the defence about whether an accused person is prepared to plead guilty to a lesser charge.
However, it's the arrangements likely to arise from some of those discussions that have tough justice lobbyists, the Sensible Sentencing Trust, worried.
There has been significant budget cuts to the Crown Prosecution Service. They are the people who represent the victims. They are now able to initiate charge compromise or plea bargaining, and the fear is that we will end up with way more manslaughter convictions than appropriate instead of murder, as well as recidivist offenders, which most of those homicide people are, out there on the streets quicker than usual, serving shorter sentences.
A sentiment echoed by New Zealand First Justice spokesman and lawyer Dennis O'Rourke.
We'll get a situation which results in lighter sentences when I think many people in this country want to see heavier sentences for the most serious crimes as a means of trying to reduce homicides and other serious offences.
What's more, while it was once the rule that victims must be told of any plea bargaining and allowed to make their position on it known, the guidelines now say all that should happen where practical and appropriate.
It's completely outrageous. That wording pretty much says negotiate. The victim doesn't need to be a party to the negotiations. How can the victim not be a party to the negotiations? It's completely outrageous.
The guidelines do at least continue to say the Solicitor General must approve any plea bargaining over murder charges.
I don't think it was off the record. I think often
Not that the lawyers we spoke to thought he'll be called on that much more anyway.
The police have an attitude that if there's been an unlawful killing, they should prefer a charge of murder and let the courts decide.
And it's been my experience that if a Crown Solicitor, having considered the case when it gets to his desk, lays an indictment for murder, he'll pursue that, always knowing that manslaughter is an option for the jury.
I don't think it's going to have as much influence when it comes to laying of homicide charges and negotiating them down to a manslaughter charge, although I think that the Crown will be far more open to those discussions, particularly if a lawyer comes to the Crown and sort of says, well, look, I think there should be manslaughter and these are the reasons.
There would be very few cases where you'd be looking at a murder and saying, well, could that be really dealt with properly as a manslaughter?
But Ruth Money isn't convinced.
I'd like to believe that in theory, but of course not all Crown prosecutors are Simon Moore, for a start. There's quite a big difference in terms of skill level and experience throughout the network. The second point to that is murder is quite a high standard of proof to achieve. So I believe that if they can plea bargain from murder to manslaughter and avoid a trial which costs the Crown millions of dollars, that it absolutely will be done.
She and the Trust will now be watching police statistics with a somewhat sceptical eye. Already we've seen in 2 of the past 3 years a jump in homicides being classified from the outset as manslaughter, not murder. At the same time, the past 2 years have seen the lowest number of recorded murders since 1995. A statistical blip perhaps, or does it suggest something else? Could it even be that all our efforts to reduce violence and by extension murder are working?
And next week, Torben looks into that question and asks if more could be done to reduce our homicide toll. We also have the results of our poll into whether the death penalty should be introduced here. Those results may surprise you.